Hi, guys. It's Kathy. I hope you're doing well. So, I need to start off by saying, it's Eric. I'm so sorry. I didn't get okay when someone leaves me a tip in PayPal and Venmo and Cash App, I get a notification. July 4th, Eric, you sent me something in Cash App, and I saw it last night. I didn't know. I'm so sorry, Eric. Thank you so much, Eric. I appreciate it. I really, really do. Hi, Kingsley. Hello. All right. So I got a job interview tomorrow, a second interview somewhere. It's at a restaurant, but I can't tell you where. Do you want to know why I can't tell you where? Because there's a piece of shit watching my stream right now who is in my personal life. Like when I told you I got fired from Big Dog, they contacted Big Dog. They did. They contacted Big Dog. Yeah. Yeah. So I know who the piece of shit is, so it's fine. But just so you know, you're not a good person. You just don't do that. It's all right. I'll get them back. I know who it is, and I'm gonna get you back. You'll see. All right. So yeah. So I have a second job interview tomorrow at a restaurant. So we'll see who calls me first. The one place, which or the other place, which can't say because fucking doxing low lives. Yeah, that you forgot the F word in that, JK, but I fixed it for you. What a piece of shit. I'm so mad. It didn't even do anything to me because guess what? I told the truth. Everything I said was 100% the truth. So what you told them I said was what actually happened. So anyway, oh, walrus. Yep. She is a walrus. Anyway, we got a good one today. I need to tell you up front, disclaimer up front. This person you see is an adult right now. He is over the age of 18 right now. So the crimes he committed was when he was juvenile. But right now, today, as we are watching him, this is an adult. So there's no minors involved. There are minor victims. They didn't personally get hurt, but they got terrorized. But and we're not going to see any victims. But the person you see does not look like an adult, does not talk like an adult, is an adult. And we are in Indiana. We're in Indiana. So Judge Claymore, I play every once in a while. He's so good. He's awesome. I should play him more often. He does not stream every day, so I can't get him every day. But this is the boy that I'm talking about, adult right now. I have to say that so people don't think I'm putting minors up on. Not a minor. This is the prosecutor who's very frustrated and angry, and so is he. And we're going to find out if what he did was worthy of adult prison. Here we go. Thanks for coming out to my special live stream, guys. I appreciate it. Thanks for letting me rest a little bit this morning. I was not feeling good, but now I feel great.
I was hoping to present some evidence to the court regarding the phone calls that came in and those phone calls being sent to an expert witness to verify his identity, as well as there's some testimony about things from the juvenile detention center that would be relevant to the court about his behavior there. Secondarily, I have a detective from Medina, Ohio, who was familiar with the defendant, who also assisted in the identification of the defendant upon contact from Valparaiso PD. And because of our investigation here, they were able to solve an open case they had in Medina County involving him in a bomb threat. I also have an employee from the Juvenile Detention Center that will verify some correspondence that was sent out by the defendant from the Juvenile Detention Center. And
Has that been presented to the court?
not yet. I was
And it
gonna
won't
mark-
be, because how is Mr. Voga to be allowed to respond to something that he hasn't seen?
Well, he's seen it. I just haven't submitted it to you.
When did he see it?
I presented that to, I forwarded those exhibits to him
When did you plan on showing the judge?
in the hearing.
What is it?
Got
It's
one,
a surprise to me.
I got one log, dated July 8th.
That sounds so cool.
So I just got it. I had no idea what it was, who the I never received a witness list, Judge. I'm firmly convinced that Your Honor is correct about the relevance of these. I'm gonna be deprived of cross-examining any of these witnesses. And to me, more importantly, Judge, they're all incorporated. Any evidence that would come forth from this point on is incorporated, as you stated earlier, into the fact that he has pled guilty to all these level 5 felonies. So I just don't,
I will make a statement right now that sort of eliminates the need for hearing evidence. Given what I
Judge, I hate you. That was so mean. So apparently, this kid made some egregious phone calls while he was locked up for one crime. And they played them during court, and they were bad. They were really bad. So she was just going to play more phone calls because we didn't see the trial. We're only here for the sentencing. She was just going to play us some more phone calls from him. The judge said no.
heard previously, Mr. Krajewski went out of his way to hide his identity, where he was, who he was, how to find him. So to hear, and I will state at sentencing that he did that. And that, in fact, is going to be part of the sentence, that he can't do that going forward ever while he's within the jurisdiction of the court. So I don't need to hear evidence of all the efforts that he went through to hide his identity because he's already pled guilty. And I will tell you, I find that he took efforts to hide his identity. So we don't need to hear that evidence. That doesn't have any probative value. So what else do you wish me to hear other than efforts to hide? And I will also say this on the record, that I have considered a matter that is pending, as I understand it, in Lake County. And I will tell you where that fits into my considerations. And that matter allegedly happened on January 26th of 2023, which also happens to be the same date of a crime in Porter County. So for the purpose of determining whether there was a crime that happened in Medina, Ohio, or anywhere else, I'm already going to find that there is evidence that there was a similar act committed in Lake County, Indiana, on the same day as a crime in
So multiple states he has done this. Multiple times he has done this.
Porter County, Indiana. So I don't need to hear evidence regarding a crime in Medina, Ohio. I'm finding that there are other acts that this defendant committed.
The other piece of evidence, Judge, was a letter that was sent by the defendant indicating how he thought this situation was hilarious. I thought that would have an impact on the court when determining if the defendant takes things seriously. They're not and this was with a return address to the juvenile detention center that he sent to England.
And you showed it to Mr. Voga when?
I literally walked it
Both from jail and out of jail. He did it a whole bunch of times in different places.
over, but it was submitted and sent on Wednesday.
Mr. Voga?
Well, first of all, Judge, again, I don't see the relevance to the way that the state has just described this is exclusively her opinion as to the intent or the mindset behind it. My client, when that was written, we don't have.
When was that allegedly written?
2 years ago.
May 28th,
The
of
J-
2023.
He was 16 years old. I mean,
What's your objection?
my
What is your
objection,
legal?
first of all, my objection is relevance. I'm not sure exactly what the purpose of that would be. It's got nothing to do with the elements of the offenses to which he is pleading guilty to here right now. I'm assuming that it's some sort of a backdoor effort by the state to maybe say that he's not remorseful, which is so tenuous. She can make that argument,
So,
but to elicit,
Wait. Stop. So your objection was it's not relevant
it's not relevant
without your argument.
without my amplifying.
How is it relevant?
Your Honor, you have a defendant who is sending a letter, and I'm not interpreting that to say it's hilarious. Those are his words.
Okay.
So that the court has to make.
Not
The
exactly.
objection as to relevance is overruled. Sergeant Malabi. Go get the doc.
Prosecutor can't read, but that's okay.
Sorry, I got
It's
that
fine.
marked as- Your Honor, I marked it as State's Exhibit 1.
Okay.
I can't remember if we hear from the cop. I think we do. That's why he's sitting there, but I can't 100% remember. He's pondering. He's frowning like that because the prosecutor does not know how to read.
The name toxic appeared in a petition to revoke his prior pretrial release. Having said that, I can't tell what this letter says. It does have the word hilarious. I don't know if that hilarity is referring to the person acting as his attorney or who called to act as attorney. I can't tell exactly what it's referring to.
I can help you out, guys. He didn't say that what he did was hilarious. There is a user whose username is hilarious. And he references this other user, this other screen name in this letter. And his name is hilarious. So the prosecutor is like, oh, see, he says this is all hilarious.
But it is a document that appears to be written by the defendant in May of 2023 from the Juvenile Detention Center, which contains the word hilarious. It is admitted. All right.
Your Honor, as far as the name toxic, Detective Lamont could give the court.
That was filed. I brought up that because that was filed as part of a notice of violation of pretrial release that was filed in February 7 of 2024, using the same word. That's how I noticed that.
Correct. I did have a member from the Juvenile Detention Center here to give information to the court about the mail log. And the date on the mail log matches the date on the letter.
I'll cut you off. Because it uses the word toxic, which allegedly was used between December 23 and January of 2024, I find that the defendant sent it.
Okay, just because the word toxic was found in the digital download. So it's not hypothetical that it was him. But if the court is finding that it's.
No, it would be too much of a coincidence to come from the Juvenile Detention Center in May of 2023 and in December of 2023 have some type of electronic post which has the defendant's picture and uses the word toxic. I find that it's him.
All right.
It's for that purpose, it's admissible.
I do have one other witness then.
Okay.
The Detective Brian Dzinski from the Porter County Sheriff's Department, who handled the Union Township school.
To testify about the impact at Union Township, is that right?
And who was present, because Union Township also had kids that were under the age of 12.
He may testify, or he may speak on behalf of the students at Union Township.
Well, Your Honor.
Morning. I'm not swearing you. You may just test. Well, it's just because he's not actually a victim. Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Could you state and spell your last name slowly for the reporter?
Detective Lieutenant Brian, Brian Dzinski, Dzinski.
May proceed.
What? I need to hear that again, guys. Could you imagine having that last name? That sounds very difficult. Here we go.
Lieutenant Brian, Brian Dzinski, Dzinski.
May proceed, Ms. Ryan.
Where are you employed, sir?
I'm a lieutenant in the Porter County Sheriff's Department.
And back on January 26th of 2023, were you the detective that was responsible for handling the bomb threat that came into the Union Township schools?
I was myself and Detective Sergeant Greta.
All right. And so you.
See, but that's the thing. In today's world, that's not funny. That's not okay. Could you imagine, like, being a parent? For a second, could you imagine being a parent of one of those children? If you find that out, I don't even know how I would, that would, because it's so common now. Hey, Sally Port. Oh my God, the parents must have gone through hell.
Union Township School itself, it covers what grade ranges?
So the building is actually one large building that's connected by a hallway. Union Township Middle School caters to 6th through 8th graders, and the Wheeler High School caters from 9th to 12th grade.
Okay. And then were you yourself at the school that day?
I did respond. I was not working SRO that day, but did come after the call was made.
Okay. And so when you got to the school, can you just kind of fill the judge in about the reactions of people that were present at the school?
Yes. Yeah. So they had moved to a procedure called lockout there. There was a large police presence at the school. The people in the know that had information of what the call's details were scared about the content of it. The people that did not know obviously saw the large police presence and the lockout procedure in effect, and more of the worry of the unknown, you might say.
And when you say a large police or emergency presence and response, I mean, what are we talking about? Who, besides law enforcement strictly, who else is responding?
So, yes, there was, I believe, 4 to 6 detectives there, along with pretty much all of our patrol units were at the school as well.
Is it Leineke or Leineke?
Were there
Hi, Ellen.
any fire department or ambulance that responded?
Not to my recollection.
Okay, so yours was strictly a law enforcement response at that point.
Correct.
That's all I have on Judge.
Thank you, DZ. You may step down.
Yeah.
I would
Bye,
like to
Dizzy.
call
Bye,
Assistant Chief
Dizzy.
Lamont for a couple questions as well.
Oh, man.
You may.
In my head, it's one of
So
those
is
two, just so
this
you know.
Evidence or is this victim impact? If it's evidence, I'll swear him, then it'll be subject to cross.
Yeah, you can.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Could you state and spell your name for the record?
First name is Mark, M-A-R-K. Last is Lamott, L-A-M-O-T-T-E.
Have a seat.
Thank you, Your Honor.
And Assistant Chief Lamont, back in January of 2023, what was your assignment within the department?
I was a detective sergeant with the Valparaiso Police Department.
And did you in fact handle the investigation into the threats that were coming into Valparaiso High School?
Just about our entire detective bureau was working on it, but I was the lead investigator. Yes, ma'am.
Did you in fact go to the school that day?
Yes, ma'am.
And can you talk to the judge a little bit about what you're seeing and hearing when you get to the school?
When I first arrived during the first incident, the school had been on lockdown. I was privy to the fact that so many parents had arrived that actually became an issue with blocking the front drive for the emergency vehicles that were trying to get in there. My attention was primarily focused on the investigation.
That would be me.
I wasn't one of the officers with Dr. McCall to go out and speak with the parents. But I know that the police and EMS fire response was overwhelming. To put it in context, the city of Valparaiso's fire territory has 3 advanced life support ambulances. For a period of 1 hour and 45 minutes during one of these incidents, 2 of those 3 advanced life support ambulances were dedicated to this call, depriving the rest of the city of those resources.
And how many fire vehicles responded?
At least 1 engine for the Valparaiso High School, at least 2 rescue ambulances, battalion chiefs, administration from the fire department. I would just classify it as overwhelming.
And
I hate to say it, but I would be one of the parents in the way of law enforcement. I would be tearing that door apart to get in that building. Nothing would have stopped me. They would be sicking the dogs on me, the police department, to drag me back. No, I would have dug under the building if I had to. I was going to get in that building.
I know the judge has indicated that he recognizes that locating the person that called in the threats was overwhelming. But were you the one that was responsible for the sifting through the digital download of electronics that were seized from the defendant?
Yes, ma'am.
And specifically within those downloads, were you able to find something directly relating to what was going on in the school to someone at the school?
Yes, ma'am. I found communication with what was ultimately learned to be a juvenile inside the school, where there was communication about planning pre and post peer discussion over these incidents.
If I may approach,
Sounds like hearsay to
what I
me.
marked as States Exhibit number 2.
Yes, ma'am.
Do you recognize States Exhibit number 2?
I do.
What is that document?
This is a screenshot.
So it's interesting you ask if the parents are here. Hi, Terry and Terry, but I said hi to Terry. So as the day goes by, this side of the room empties. And I think they're here because, you know, they do the mini hearings in between breaks of the sentencing. Okay. And this side of the room fills up. But I don't know if they're the parents. They're from many different schools in a couple states. So I don't know. I mean, everybody probably has the Zoom link. So they're probably watching in the Zoom link. Oh man. You don't even know. And that is true. All right.
From the download of computer and phone devices that were seized from Ryan Krajewski, the one item, the one particular artifact, this piece of evidence is a communication that appears to come through Discord, which is an online communication platform. The message, and it appears to be received by Mr. Krajewski's device, says, "Call in the bomb threat at 9:30 to the police department." And the timestamp is dated January 26th of 2023 at 7:35 a.m. and 25 seconds.
What an idiot. So now you know, people, everything you say in Discord can and will be used against you in a court of law. Just like everything I say here will be used against me by some asshole.
Yeah, I would move for admission of this exhibit. It's part of previous discovery that was tendered.
No,
State's Exhibit 2 is admitted.
Now, you personally, Assistant Chief, can you talk to the judge about the impact of the scope of this investigation has had on you?
Between me, my police department, the fire department, the Valparaiso Community Schools, I would also categorize it as overwhelming. Hundreds and hundreds of work hours were spent both on initial responses and on the investigation. In the aftermath of this, an exhaustive effort was dedicated to this investigation.
That's all I have.
Any cross, Mr. Voga?
just very briefly.
You may.
You're aware, Assistant Chief, that the incidents that have already been mentioned in the victim statements and even your preliminary, even though they weren't noted, that was January 9th and then January 17th.
Yes,
correct?
sir.
Okay. Are you aware that those are the two counts that the state dismissed?
Yes, sir. I
Under
am.
this? Now, going through the copious amount of discovery I got in this case, I saw your name a lot.
Yes, sir.
And you moved with, and I'm asking you this directly. It appears that you moved with incredible speed and efficiency in locating Ryan, correct?
I don't think I would agree with that, sir. It took days and days and days.
Maybe you might be too humble. I mean, I'm looking at least in the discovery when January 9th, the first incident, the one that count one that has been since dismissed, that is when you already were making connections through your hard work, linking up these telephone numbers. You found the spoof number and you were able to immediately on that day determine that at least the source was from out of state. Is that not correct?
When we ultimately traced the call back, I'd have to refer to my report, but I believe it was after January 17th that we determined we had our first lead on the viable location of that. The spoofed phone numbers we followed immediately that
Yes,
day, which led
yes.
us ultimately to dead end, sir.
In fact, however, again, you will testify truthfully.
Spoof phone
that
numbers.
Based on your own police reports, you knew the identity of this boy, Ryan Krajewski, before the January 26 calls to the other school corporations.
Yes, sir. That is correct.
In fact, you already had a warrant ready to go and it was issued for Ryan Krajewski on that same day because your investigation had already been completed as to his identity. Isn't that correct?
We obtained the warrant after the calls on January 26th,
Yes.
but it was obtained that day. Yes, sir.
Right. So by that time, you had, and obviously, and I think just in prior encounters like this, we've acknowledged that this whole swatting offense is a relatively new phenomenon, correct?
I couldn't speak intelligently to how many
Okay.
years it's been around, but
Right. What we can agree on is that the essential element of swatting is to in fact provide false information by not providing your real name, correct?
No,
That is, if it is.
it is to get the police to SWAT the school. That's what it's for. It has nothing to do with your name. That's the primary goal of swatting.
Reported to the police. I do believe it is a drastically separate issue to contract the school.
So it's dramatically different. I mean, obviously, if Ryan called and said, I'm Ryan Krajewski from Medina, Ohio, and I'm doing this, then you wouldn't have had to have done all of that, because that's the offense of swatting, is calling in places as a hoax, the word that was used prolifically in your police reports and discovery.
I would say swatting is contacting a police department to file an official report, where this investigation step far over that is threatening staff directly at the school and telling them that dead bodies will be on their conscience.
Sure.
Because they didn't do that. That was reported directly to a victim.
So even though you certainly did not know anything about the seriousness of that January 9th call, by the time the 26th rolled around, again, just what I'm seeing from what the state gave me, every agency, including the Porter County Sheriff's, the police, already had described it and defined it countless times in their reports as a hoax, and they already knew that he was the caller. Isn't that correct?
I'm not sure if representatives from the sheriff's department or Portage knew that level of detail to my investigation at that point.
Have you seen their narratives?
I don't believe I have, at least not recently, sir.
Officer, thank you, or Assistant Chief.
Okay.
Thank you, Judge.
Any redirect?
No, Your Honor.
Thank you, Assistant Chief.
Thank you, Your Honor.
I have to make another disclaimer. I've disclaimed that my wife was a teacher. My kids went to Valparaiso school system. When Sheriff Reynolds was the sheriff, I participated a few months in programs where all of the school superintendents of Porter County would meet at the sheriff's department with local police departments and with some of the judges to address school safety issues, spoken generally. The involvement of the court, Mr. Voga sort of knocked the rust off a little bit. The involvement of the court was that the court might have needed to have been involved in issuing search warrants, assuming that there was some crimes that were occurring. So Sheriff Reynolds met with each of the school superintendents, and I attended those meetings. Having said that, it's
That's my
now been
cat.
years
Hold
since
on,
I
it's gonna
attended
go away.
those meetings.
That's my cat on my 3D printer. That's my cat, mine, on my 3D printer. Look, I spent all this money on a 3D printer. Do you see that, guys? I'm very rich. I'm so rich. I can just buy one of those massive 3D printers. Wait, that's not my 3D printer, and that's not my cat. Guys, that's Bill's. That's Bill's pretty kitty who loves Bill's 3D printer. And every time Bill tries to get to the printer, the cat does not want him to touch it. Get away. Get away from my printer. So Bill thinks he owns a 3D printer. Bill, you're wrong. You don't own a 3D printer. The cat owns a 3D printer that you get to touch only when the cat's not watching. And then you can do your work. That's pretty damn nice, though. Look at all that, guys, over here. That's nice. That's really, really nice. Yep. Oh, come here, kitty. I think I need that cat. I need to take that cat. I need more cats in my life. Sorry.
I don't know if they still occur. At one of those meetings, a person from the Indiana State Police spoke to the police officers who were present regarding a shooting that happened in a school system down by Carmel. And I was present during that discussion. I haven't attended those meetings in years. I don't know if they still exist, but I'm laying all my cards on the table. And I've been to these schools. When my kids went to Valparaiso High School, it was different configuration. But I've been to all these schools. I know these buildings well. Anything else, Ms. Ryan?
No, Your
Let's do this. Let's take about a 5-minute break and then we'll come back and hear from the defense. All right. We'll be in recess for 5 minutes.
Yo, that's savage. That's savage.
Me off no type of social media. I away block from the email and her away, but not.
Oh, oops. That's me. Don't worry about
Just
that.
block
Don't worry
me.
about that. That's a different case.
Miss Davis.
Why would for her life? Me, April.
Miss Davis?
I thought since they
No,
were
sir.
taking a break, I could get some work done on another case.
Well,
And I did, and I shouldn't have.
Miss Davis.
everybody go to jail.
Time would like to make a statement to the court.
All right. So with that argument from the state.
Thank you, Your Honor. This defendant has been through the juvenile system in the state of Ohio for internet-related crimes. He has been held in detention in their facility for various lengths of times.
How do you want to respond
He
to?
has been on probation. He has had probation
Hi, Jack.
revocations
Jack.
filed against
Jack.
him while he was there. These all predate what happened in our county. There is also the pending charge in Hobart, which occurred on our same day of January 26, 2023. And you have also in the pre-sentence report that there was a charge that was filed by Medina County, Ohio, that was a crime that occurred on a different day from ours. However, they chose to dismiss it because we had the warrant to bring him over here to Porter County. So, Your Honor, you have before you a defendant who was waived out of juvenile court. And when you look at the statements that he made in the pre-sentence report, I think they're pretty telling, because he's indicating to the court, and it is on page 8 of the report, that he did this in response to an alleged bullying incident that was going on at Valparaiso High School, which had nothing to do with Portage, with Wheeler, with Union Township, with Washington Township. And he couldn't give an explanation to the probation officer as to why he made calls to them. I know, Your Honor, in our previous hearings at the bond hearing, you've listened to these calls. You've heard them. You've heard the way in which he speaks, the tone that he uses, the vulgarities that he used when he made these calls. He's making them
You both
to
swear or affirm?
administrative staff who are answering the phone and just doing their daily duties. And as Assistant Chief Lamont testified and talked about, that he's telling them the dead bodies are going to be on your head because you're not doing what I'm telling you to do. And the increasing anger that you hear when he goes through these phone calls when he's not getting the response. Especially, Your Honor, I want to refer you back to one of them where he was so angry because the school wasn't evacuated. The school went into their lockdown procedure because they didn't know if there was a bomb in the school, and they were not going to send the kids out into the hall or outside the school, not knowing whether there was an explosive device waiting for the kids. So they were in lockdown, and that made him angry. because people weren't doing what he was telling them to do, most specifically law enforcement and school officials. It wasn't just one call, it was multiple calls. And I acknowledge that they were on January 26th. When the court looks at and assesses whether this is a single episode of criminal conduct, absolutely, I concede that the court has to look at that. However, I did present case law to the court in my memo indicating it's not just the time frame in which it happens. That's not the only factor for the court to consider. It also considers the location as well as, is it the same set of victims or is it a separate set of people, which we have. Now, you have someone who's calling in bomb threats to schools, and when you do these anonymous internet bomb threats, you never know who's going to be in the blast radius. And on this particular incident, we've got kindergartners, Judge, at Portage High School. At least 20, potentially 80, but at a minimum 20. We got kindergartners, little ones that are in the fallout. You've got middle schoolers, both at Washington Township as well as Union Township. You've got little ones that have nothing to do with
Sitting in a classroom, hiding, scared. Yeah, I mean, I don't know if they told the kindergartners what was going on. Sitting in a classroom, scared.
your bullying incident that didn't even happen to you. It happened to someone else. And the impact, I think it's clear, Judge, based on what you saw and what you heard today, the tentacles of that fear spread out way beyond the person that answers the phone. The law enforcement officers, the emergency responders, both fire as well as paramedics and EMTs, they're staging for a mass casualty event, meaning they may have to take care of little kids, teenagers that are injured. They don't know, and they're sitting there waiting to find out. Just like the parents were waiting. The teachers, they're in protect their kid mode. They're their students, but they were prepared to treat them as if they were their own children, to protect them, to get in the way of harm, to keep them safe. And that has an impact. And you heard from Dr. Tobin that there had to have services that were offered to the staff and to the teachers and counseling to them because of that. And this is something that I think is just lost in translation, that he just doesn't get, because he sees the world as it's all about him. It's not about the impact and the effect. He looks at this as a joke, that it's no big deal. Nobody got hurt. I don't know why you're making such a big deal about it. But here's the problem with that thought process. You've been through the juvenile system in the state of Ohio. You've been getting services, all kinds of services, both from the probation departments there, but also from doctors there. You had letters that were submitted to you from...
That means he committed other crimes, and I don't know what they are, before this. Enough of other crimes that he's been in there for a while and is getting all these services. So not just, he stole a bicycle. You know what I mean?
His own therapists, his own doctors, showing you that he's getting treatment, but it hasn't had an impact because he had at least one of those therapists while he was going through his juvenile cases in the state of Ohio. So why the court looks at that is, what do you think is going to happen in the future? You have to look at that. And that was part of the cases that I submitted to the court, is that will he commit other crimes in the future? That's in Tunstill, Tunstill v. State, 568 Northeast 2nd, 539.
Bill, Bossy wants you to do a stream tonight. And he just paid me $20 so that you would do a stream tonight. And that math checks out to me, I think. I think all that math checks out. But If you do a stream tonight, I'm gonna be there. So do a stream tonight.
And
Thank you, Fozzie. Thank you, thank you, thank you, thank you,
I'm
thank you.
looking at this judge as his behavior. You know, the letter from the juvenile detention center, he is now detained. We went and got him from the state of Ohio, and he is in our facility, and he's sending out a letter on juvenile detention letterhead or the return address on the envelope, talking about how funny things are. That's how he processes information. I think the court could look at that.
No,
and
he
use
didn't.
that
He
as an
didn't.
aggravating factor.
He didn't do that one.
The defendant, in the case that I submitted to you, Judge, which I believe was Brewington, Brewington v. State, that's from 2014. 2014, they were already saying this, that in light of the stark reality in which our children attend school, a statement made by, in that case, a 13-year-old aware of those realities, not to attend school on a specific day, combined with an image of a character pointing handguns, can no longer be ignored or in hindsight be characterized as a joke that can be casually disregarded, but must be regarded as an intentional attempt to create fear and apprehension. And that's exactly what you heard from Todd DiCarlo talking about. This was terrorism because the point of the call is to put people in fear and terrorize them in order to accomplish what you want to accomplish. And that's pretty much the definition of terrorism. You have, as part of, and the court referenced this a little bit earlier, about the petition to revoke his bond because of
Messages
so-
December of 2023 through 2024.
correct. While he's in your courtroom and you're the judge. You also had a notation in there that he had a smart TV and the Oculus glasses, if you recall.
We're gonna hear from him. We're gonna hear from him, guys. Don't worry. We're gonna hear from him real soon.
Already, he's testing you and your authority because he's doing this while he's under your authority of this case. Again, you're seeing how he is
Thank you,
processing
Jen.
the
Thank
world.
you, thank you, thank you.
I
Bill is better.
understand that he has
Bill's
been
more professional
diagnosed with
by
certain
far.
things, anxiety and depression. In the pre-sentence report, you see Tourette syndrome and the oppositional defiant disorder, but yet in the letter that you got from the defense today has no discussion, no mention of what he's been diagnosed with.
That's not true.
In
The letter from his therapist says oppositional defiant disorder. It also says dyspnea, and it says anxiety. It says depression. It says a new diagnosis. So what you said isn't what's in the letter that you just saw.
Tourette's is not in that letter, Judge. I apologize.
okay.
Tourette's is not in that letter.
Right.
Okay. So you have one of the mitigators the court can consider is him pleading guilty and taking responsibility. And I provided case law to the court, which says that has to be weighed. The evidence that the court heard at the bond hearing, some of the testimony that you heard today, you know that we had the voice analysis that was done, the digital downloading that was done, that was back to him. The state had a very strong case against this defendant. So although I understand that you have to consider it as a mitigator, I'm asking you not to give it a whole lot of weight because we did have very strong evidence against him.
Okay, now that you know the little boy has been diagnosed with all those things, now what do you think? Do you think they explain it? You think, oh, he's sick?
This particular defendant, I had indicated to the court in my memo about, remorse. I was really struck by some of the comments that were made in the pre-sentence report by the probation officer that talked about, she was questioning his sincerity. Just on her communications with him about not, his responses suggested the possibility that he is expressing what he believes is expected of him rather than demonstrating genuine insight or remorse. And that's a probation officer who was just going through and doing the report, but even hesitated as to that point. What I'm asking the court to do, Your Honor, is to take into account that we have different schools, different set of victims, to make this not a single episode of criminal conduct. And I am asking the court to impose on him 3 years on each count, consecutive. I'm asking for 1 year on each count in the Department of Correction with 2 years of probation to follow on each count. If the court deems this to be an episode of criminal conduct, then I'm asking for 1 year Department of Correction on each count, followed by the remaining 2 years of probation, because the sentence would be capped at 7 years under the law. So I don't know if this defendant believed in all of his efforts to hide his identity, if we in Porter County, law enforcement wouldn't track him down or couldn't track him down or didn't have the backbone to do it. Whether he believed, once they figured out who he was, whether the state of Indiana would do anything to him because he was in the state of Ohio, or he thought perhaps he would stay in the juvenile court, just like he had been in juvenile court over in Ohio. Well, Mr. Krajewski now knows what law enforcement in Porter County will do to protect their kids. Porter County citizens deserve better. And luckily for us, we had a team of officers who said enough is enough. You don't get to do this in Porter County and get away with it. Kindergartners deserve better than that. Middle schoolers deserve better than that. Teachers and their families deserve better than that. Parents deserve better than that. High school students deserve better than that. He may not care who is affected by what he did, terrorizing Porter County, but certainly I think the state of Indiana cares, and I think this court cares. And in light of that, with his prior record, with victims being under the age of 12, with a lack of remorse, and then he finds it funny, and it's probably not going to stop. Because if you look at the statement that was made by the judge in Ohio on his first juvenile adjudication over there, he said he basically recognized his brilliance when it came to computers and IT. But the court had already had concerns that he was going to violate state and federal law. So you've got a judge from back in 2020 already saying, I'm afraid he's going to violate the law when it comes to IT things. And that judge was not wrong. In light of all of that, Judge, I am asking you to send him to the Department of Correction and then give him a term of probation and let him prove himself at that point. But enough is enough. You don't get to terrorize citizens and students in Porter County. Thank you.
Yo, good job, ma'am. Good job, prosecutor in a tiny little town. Good job, police department in a tiny little town. Because, you know, him thinking that they're not going to be able to find him from masking his identity, and they're not going to put the effort into it because it's a tiny little town, is not far off the mark. He's not wrong. I mean, he got unlucky. They did. But normally things like that are a lot harder to figure out than you think. And they put in the work to do it. And she put in the work, and she did a good job. And Maiko thought about the poor lunch ladies. I wasn't even thinking about the poor lunch ladies, too. I was just thinking about the parents and how terrified they were. Lunch ladies make what? Minimum wage? And they can die every day?
Mr. Fogel, your client has a right to address the court.
And he's going to. But I want to know what he did in 2020 that the judge said this boy is going to be a criminal later. This boy is going to use the internet and become a criminal later. Now his crimes weren't exactly the internet. They were phone calls, but some of them were emails. But I want to know what he did, and there's no way for us to find out because it was juvenile record, and you just can't look juvenile records up. I could go to Ohio. Nope, this is Indiana. I could go to Indiana and get a job there in the juvenile department and then look up old records and then find out. That would be dedication to this channel. I'm thinking about it.
He may do so before you speak, after you speak, as long as it's not during you speaking, that right is his.
Certainly, do you want to go ahead and do that now?
Your Honor, would you like me to stand?
You may stay seated.
Good morning and thank you for the opportunity to speak. I want to begin by sincerely apologizing to the court, the community of Northwest Indiana, and to the agencies involved. I deeply regret my actions, especially if I put anyone at risk. Looking back, I was just 16, making poor choices and allowing myself to be influenced by the wrong type of people. I lacked direction and maturity. I had no friends with nothing to look forward to and was hurting others' emotions as I had no way to help myself. But I've grown since then. Today, as a young man, I'm proud to say I'm employed full-time, graduated high school, in a stable relationship, and in building a life I can be proud of. I've taken responsibility for my past. I'm committed to using my experiences to help others who might feel as lost as I once did. I respectfully ask for forgiveness from those I've affected and of this court. I'm determined to continue moving forward, not only for myself, but for the people who believe.
Anything else?
No.
Mr. Voga.
Thank you,
Just
Your Honor.
remember, they said that he wasn't the one getting bullied. It was his friend that was getting bullied. So that's why he did this. Because he was in jail. See, he wasn't getting bullied in school because he was in jail.
I think the first thing that I would ask to specify for the court's instruction here is when the state is and I get it, there's some leeway involved when there's arguments, but when there are some things that are just factually inaccurate, I feel compelled to at least correct those factual inaccuracies. And it's not my opinion. It's right there in the PSI. So the first thing that I would ask the judge to incorporate is, I've heard this throughout my entire representation of Ryan, that he has committed these swatting offenses in the past. He has not. It was frustrating, but then the PSI did in fact reveal that these were, as Ms. Ryan stated, internet-related crimes, but I think that our probation officer used crimes of technology. The last one that was filed by Medina County was a hold gap. It was filed roughly at the same time that the warrant for Porter County was issued, and that was the mechanism that they used to detain him in the JDC out there to transfer. So again, that is incorporated into where we are here today on that. That's why it was dismissed immediately upon him being transported down. That was the way that they detained him. Everything that I'm hearing, I feel like I just have to keep on bringing up this one irrevocable fact, and that was when these crimes were committed, Ryan was 16. He was 16. I've never once, as Ms. Ryan relayed to you, I've never once heard him say, what's the big deal? Every encounter that I've had with Ryan, starting back 3 years ago in the JDC, he's been a quiet kid who has done nothing but comply with every directive. The voice analysis, there was no fighting that. The only fighting came from me arguing to both juvenile magistrates that I felt that a boy of his age, based on these charges, should reap the benefits of the juvenile system. Obviously, that didn't happen. But aside from those courtroom battles that were legal exclusively, Ryan has done nothing but cooperate. Listening to the victim impact statements, I think it's always very good. I think it brings an element of reality and gravitas to this. And I mean, I think it's good for Ryan to hear that. I really do. I think it's part of this process that he's going to have to go through as he continues to accept responsibility. Some things, yes, I'm moderately chagrined about it. A lot of these, why to this day, the state dismissed what I felt were their two strongest cases, where it was on January 9th and January 17th. Still, it confounds me, because as
This
I
guy's
was
an
plowing
idiot.
through the discovery, Judge, what I saw was then these rapid boom, minute after minute after minute calls on January 26th that he has pled guilty to and he has admitted to doing from the very beginning. By that time, every law enforcement community had been in touch with every school corporation in Porter County and actually in Lake County. So they knew.
Did he just point out bad crimes that his client did during the sentencing on purpose in front of the judge? What an idiot. I mean, is he complaining that the state dropped two of its most promising cases against his client? Did he just say that? What are we watching?
Right away who that was, which is the whole reason why, when I think it was one of the smaller middle schools, the response, yes, I'm Mr. Dzinski of Union Township. He said, yes, we had middle schools there. It wasn't so much the worry of shooting, but it was the worry of the unknown, because at that point they weren't taking any measures like they did in the first two counts. The first two counts, yes, definitely. That was some poignant testimony about, like having to make the decision to evacuate the school. But when it comes to, some of these others, it just seems like, well, wait a minute. I think that the state kind of knew already that even though those first two incidents may have been the very first times that Ryan's voice was heard, I'm just telling you, this officer and his support team, that law enforcement division, I don't care what they say, they moved. To me, I'm looking at the report, they moved quickly. They were very efficient. So they got on top of this right away. And I just think that bears at least some element of conversation about that. And again, Judge, there's so many other things. I had a hard time writing them all down. This supposed letter in the JDC that the state is attempting to use to, for some reason, find that Ryan was not remorseful. The word hilarious is spelled with an X. It was a username, which is why it was out of context when you read it. It's out of context because it wasn't anything about him laughing or joking or doing anything like that when it came to what his circumstances were. This is a 16-year-old boy that was in the JDC, which, by the way, the records would reveal, the prosecutor has them, that he was incident free. He was in their honors section the entire time. So this young man demonstrated, even when he was in the juvenile detention center, that he was capable of following
That's
the
pretty good.
rules.
You
That was
finally
the
said
other
something
thing.
good.
I'm not sure what Ms. Ryan was reading, but in the PSI, it specifies very clearly that there were no probation revocations. He was not numerously violating his probation. I'm not,
There was a notice of violation of pretrial release when he was within the jurisdiction of this court.
yes,
That was filed on February 7th.
Yeah.
I'm aware of what happened in the jurisdiction of this court.
yes, okay. I just wanted to clear up that factual aspect of it because I think that does bear something. So then moving on, Judge, yes, the consecutive and concurrent argument, without any doubt, that lies heavily in the court's discretion. That is something that every bit of case law gives you, Your Honor, a lot of options, a lot of creativity when it comes to that. But again, I have to stress, Judge, in this situation, concurrent sentencing strikes me as reality that this was intended to incorporate. When the 5 counts that Ryan pled to were VHS, Portage, Wheeler, Union Township, and Washington Township, those were all made on January 26th within minutes of each other. And I see that as definitely one episode of conduct.
Yeah, we got to put some waiters on this. This lawyer is just lying so hard. I know the prosecutor did too, but if you like these judges and you like these courts, you can only get them here, guys. So make sure you like and subscribe. Subscribe to get the courts no one else is getting.
And again, between January 9th and 17th, our law enforcement here not already knew that it was swatting, that it was a hoax, and that there was.
Wait, stop. For a second. Are you trying to say that because Medina, Ohio thought that your client was committing crimes, that it's okay for your client to continue to commit crimes? Because
No,
if that's
Thank
the
you,
case,
Jen.
I wouldn't make that argument.
no, that is not even remotely what I'm saying. What I'm saying is there's a huge stark difference when you have the 5 counts that Ryan pled guilty to. I'm talking about consecutive versus concurrent, that it bears consideration that those 5 counts all took place with phone calls that were made within minutes of each other, Judge.
Thank you, guys.
There's no
Thank you.
minimization here. This young man sat down and pled guilty in front of you to 5 level 5 felonies. He understands where he's at here, Judge. That's not it at all. I just say that I think that
Most people don't even have 1 level 5 felony. He has 5.
concurrent sentencing is something that I would ask the court to give serious consideration to. Again, it's right there. The reports indicate that the officers already knew that the suspect was calling VHS again. They used the word again. Police reports are riddled with the word hoax, and knew that the threat was not credible. So
1
We
year.
just heard Dr. McCall
Thank
say
you.
they have to treat every
Yeah.
charge as serious. Otherwise, somebody
Yes.
ends up dead when they don't take it serious.
Absolutely.
I wouldn't make that argument anymore because it's not going anywhere.
So as far as then going through the state's memorandum, I just looked at some of these improper aggravators. When we look at the history of criminal behavior, yes, of course, you can look at just even one adjudication, you can find the criminal behavior. But I would ask the court to take into consideration that, yes, these were technology offenses. This is a boy who was 13 back when that happened, and he successfully completed probation all the way through. The lack of remorse, I don't know what to say about that. I haven't seen anything other than this boy being remorseful. The unsolicited opinion by the probation officer just kind of came out of the blue. I underlined that as well. And no, even though the narratives that you have, Judge, don't mention that.
Whoa. Unsolicited opinion from the probation officer? Isn't that their whole freaking job? To give their opinion? So, remember what I told you? This side emptied out and this side filled up. I don't know if they're parents or not, but yeah.
Tourette's, the medication that he's on is for Tourette's. It's for the tics that he gets as a result of that, and some of the other things that I believe when we look at that as a statutory mitigator, most certainly is something that I think the court can consider is the mental health and the physical condition of that defendant that you are hearing for sentencing. And it's right there. As a matter of fact, I mean, we have it documented. This boy has suffered from anxiety and depression when he was all the way up between 12 and 13 years old. He's been on Cymbalta since 2019. Oppositional defiant disorder in 2023. The youngsters had 5 suicide attempts, 1 self-harm incident. This is all before this has taken place. So his mental history is something that is terrifyingly sad, Judge. And it's something that we have to take our clients as defense attorneys as they're presented to us. This boy has had a well-documented mental health history and physical problems such as Tourette's. We know those symptoms of Tourette's. I can see exactly how that plays into it. And I am asking the court to give that some significant mitigating experience. The victim being the victims being under 12, Judge, to me, the only thing I can say about that is yes, we heard some victim statements in there. My research of that topic shows, again, not that it's an invalid aggravator. I'm not saying that, but more importantly, it's how much weight is given. We already know, because he's pled guilty to this level 5 series of felonies, how important that is, and that he's taking this very seriously. But I was looking at those cases and they all involved horrific crimes of physical and sexual assault to 12-year-old and under children. That intent of the statute, when it came to that, at least based on the case law that was being addressed, those were the types of cases. I'm not saying they don't apply here, Your Honor. What I'm saying is I'm asking if the court does see that as an aggravator to keep that balanced. Then going on, Judge.
Keep it balanced. So he terrorized the little kindergartners across different states in many different schools, but they didn't actually get hurt. So they were just terrorized. It's not a big deal.
In addition to not having a probation revocation in the past, we have a probation officer that specifies right there, low risk to reoffend. That they actually put that in the mitigating circumstances. They actually had that in there, that there was a low risk category to reoffend, therefore they didn't.
I don't know. Guys, what do you think the charges are? 5 charges, 5 felonies. What do you think they are? I mean, terroristic threats is not a felony. I know this. I don't know what the felonies. He swatted a whole bunch of different schools. Now, they're only charging him with the schools that he swatted in this county. That's why it's not federal. Because yes, he did it across 2 states, but they're each of them are dealing with it in their own way. So this is just for this county. I don't know what the charges are.
We conduct a full assessment. So clearly, even our own probation department specifies that the person is likely to respond affirmatively to probation. They have that in there. They also have in there the person has a history of criminal or delinquent behavior. But even the probation officer wasn't about to jump into with some of these others. I think that what probation was doing was listing the ones that she thought were absolutely the ones that the court should be looking at. I just think that she should be looking at, and I think the court should be looking at, respectfully, a few more mitigating circumstances. The imprisonment resulting in undue hardship. Absolutely. Remorse. Yes, he is remorseful. There's nothing in here that would indicate that this boy is anything but remorseful. And nor in my 3 years with him has he demonstrated anything other than that, including
He's so remorseful that he did it once, and then he went to jail, and then he did it again and again and again. That's how remorseful he is. Guys, watch the viewer count. Every time I pause it,
going against, I think for the second time in my career, going against my own legal advice about pleading to these 5s. I thought that I had time to get the state down to 6s. And he said, no, I'm going to do it. I want to do this. I want to own up to it. I need to get on with my life. I'm growing over these last 3 years. I've been making improvements. And his therapists are confirming that. His therapists are showing that this boy is on the right track. He's graduated from college. From high school. He wants to go to college. He's working a full-time job. I'm not sure when it comes to that acceptance of responsibility, if we could define it any better. This isn't even, I know sometimes, Judge, we were here, what was it, last week on a sentencing, and we brought up the acceptance of responsibility. There were a lot of lenient terms that were incorporated and built into that plea agreement. There's absolutely no doubt that the court certainly has the right to look at that and say, yeah, I see that acceptance of responsibility, but it looks like the state probably took that into consideration when they gave you this plea agreement. He's pleading to 5 felonies with an argued sentence. So then lastly, as we get to the mental illness aspect, I think that the pre-sentence investigation report, along with the letters, clearly indicates exactly that's what it is. So I'm going to leave, Your Honor, just with the one last thing, and that is, obviously the age of the defendant is something that the court must take very seriously. That's replete through the case law. Scientific research shows key developmental differences between youth and adults. And those differences impact a youth's decision-making, his impulse control, his susceptibility to peer pressure. These are documented. This is not just me throwing out these opinions. The U.S. Supreme Court has repeatedly recognized that youth are less blameworthy than adults. Not that they're not blameworthy.
8 people left last time I paused. 8 people left the stream. I need to stop pausing, but I can't help it because this guy is frustrating the hell out of me. Why is he saying these things? Does he want? Maybe. That makes sense. That makes sense, guys. This attorney has to defend him, but he doesn't really think that this kid should get off with just probation. So he's throwing the fight. He's throwing the fight to make sure he has to be, because why would he say these things? Judge, my client did all these crimes. But don't look at that, Judge. These horrible crimes. Don't look at that. The police officers knew it wasn't true. So he's really not guilty. No one got hurt. And my client is very, very remorseful. So remorseful that he wrote letters about it while he was in prison for it.
But their full frontal lobes aren't even developing yet. I've watched this boy mature for the last 3 years. He's the exact age, as I told you, Judge, myself. He's the exact age as my youngest son. So I have seen them grow. I'm telling you, Your Honor, who he was when he was 16 acting this way is not who this young man is right now. But going on, and the Supreme Court has
2 people left.
that they
Remember,
are
there's
more
a delay.
capable of change and rehabilitation. And that is where, Your Honor, I am respectfully imploring you. I think sending this young man to prison for any length of time would be a grievous, grievous thing to happen to him. That concept is terrifying to me, especially with so many other remedies of imposing justice being at our disposal.
You're terrified?
I have the ICUs,
Judge,
and I'm
he
gonna get
terrified
into
his own
that,
lawyer.
in just one second. ICU, state certified agency. They do community corrections all over the state of Indiana. They do transfers out of state all the time. A very high functioning, excellent agency. However, getting back to the punishment of children, like adults. It's been specified and documented again that that does not advance our public safety in any.
That is a valid point. Finally, he hit a valid point. He should have leaned into that. This was a child, and we want to, we want to punish him like he's an adult and he's a child. That probably isn't going to work, but that's where he should have leaned into from the beginning, not all that other bullshit.
Way. So if there's any fear that he's going to do this again, he's on probation, Judge. He's going to have all sorts of levels of accountability there, that if he does try anything like that, which he won't, but if he does, there are things built into it. Research shows that as a youth matures, they are substantially less likely to reoffend. Again, making him a good candidate for probation. Locking children up for years will extend incarceration well beyond the time needed for them to be rehabilitated. Adult incarceration opens up the dangers of violence, trauma, sexual assault in prison, physical assault, suicide. Why would we want to be risking that when we want to rehabilitate him? There's got to be a way other than the state's request to 3 years, 1 year, 6 months is going to be a life sentence for this boy if he goes to jail.
Wait, hold on. I need to think about that one for a second. 6 months is going to be a life sentence for this kid if he goes to jail. Huh? What?
In Your Honor, with the greatest intensity, please, if the court isn't going to impose a sentence above and beyond probation, have him be placed on electronic monitoring. Put the restrictions that you feel are safe, comfortable, solid, and just. Make him continue going counseling. I mean, my God, he's got counseling next week. He sees his therapist. He goes to jail. Then he doesn't even have that. He has survival to worry about. And to me, I believe at that point, Your Honor, we have to examine the beauty of our justice system and not its potential failures, because I don't want to fail this boy.
Fast forward 6 years from now, when there's another juvenile in this court, and the lawyer is saying, it's not his fault, Judge. He was swatted when he was a very young child in kindergarten, and it changed him. He got terrorized about everybody and everything. He only committed all those murders because he was protecting himself. All because when he was a kindergartner, he got swatted.
I think that he will be able to prove to you, Judge, what kind of a young man he can grow into. And that's what I'm asking you today. That I'm not going to ask for anything specific, Judge. I know that there's so many complications with this, but I am asking that you impose a concurrent sentence. And I ask that if there's any punishment of any sort, that we put him on house arrest, electronic monitoring through ICU.
He did these crimes while in juvie.
That work. See how he does. I think he's going to do well, Judge. Thank you.
Judge, may I address 2 things?
You may.
Page 4 of the pre-sentence report, the October 13th, 2020 entry, probation violation filed. Top of next page, admitted to allegations. So he did have probation revocation. And secondly,
judge said
as
that.
for
Shut up.
the charges that he pled guilty to, it was a conscious decision on the part of the state to have him plead guilty to 1 count per school.
Which makes it separate victims.
Savage.
Right.
There are things that I must legally say when sentencing. But before I do that, I'm going to say a couple things that sort of predate the sentence. On June 21st of 2023, and this is what no victim has testified about or spoke about, not subject to testimony or to cross. Mr. Voga stood up in this court and said, well, nobody was hurt or something along that line. And I stopped him. And I said that I will be judicial. That doesn't have anything to do with this case. Whether somebody was hurt or not doesn't matter. What we heard from Assistant Chief Lamont is that there were 2 ambulances and fire engines that were called to Valpo High School. So think of this. And what we heard from Mr. DiCarlo is, as a trained law enforcement officer, somebody comes in with guns and they start shooting people by accident. Then you have little kids, less than 12, shot and killed by someone responding to a fake bomb threat. But what I said to Mr. Voga in June of 2023 was, there are 2 problems when ambulances and fire trucks, not to diminish law enforcement officers, but when they come to a bomb threat, is this. They could get into a car accident as they're speeding to rescue someone. And worse, at that point, if a house is on fire or if somebody needs an ambulance, the fire engine is at the high school and not going to put the fire out. So as far as we know, there weren't any other people who were actually harmed as a result of ambulances not being available or fire engines not being available, but the community was victimized by this, not just the schools. That's one thing. And I disregard a lot of what Mr. Voga says. It's his job to be a lawyer and he says things. But
I disregard most of what Mr. Boa says. I disregard what he said. Yo, Judge, you're not allowed to do that. You gotta listen to the attorneys. So did we.
on April 16th of 2025, I sat right here, as Ryan was sitting right there. Mr. Vogt was there, and Ryan Krajewski, at that point, or give or take, 19 years old, pled guilty, despite the fact that his lawyer was telling him not to. That's either remorse or he doesn't believe in his lawyer, or stupidity. One of the door number 1, door number 2, or door number 3. So I've heard a lot of predictions, and I've heard a lot of psychological analysis by 2 lawyers and a probation officer, none of whom are psychologists or therapists. I give their statements whatever weight they're worth. There is in the record evidence from a therapist or psychologist or mental health professional. But I'm going to explain what I give the most weight to, as I'm required to do under the law. So under the law, if I can find my notes, I'm required to say this: I accept the plea agreement as written. I enter judgment of convictions under counts 3, 4, 5, 6, and 7. The sentences in those counts will run consecutive with each other. They will run consecutive. I'm going to explain in greater detail. They will run consecutive with each other because there were different schools and different victims involved. And I started off by saying the entire community is threatened by not having an ambulance. The law, though, says that the maximum sentence that could be imposed for a level 5 is 7 years. Based upon that, the sentences in counts 3, 4, and 5 run consecutively with each other. Counts 6 and 7 are concurrent with each other and also concurrent with count 1. I find I'll set forth the aggravators and mitigators, which I'm required by law to do, and then I'll set forth the actual sentence and the condition, because I told you how the sentences will run. I find as an aggravator, the defendant does have a criminal history which predates this, as well as an act that allegedly occurred on January 26, 2023 in Lake County, Indiana. So I find as an aggravator that the defendant's criminal history. I find as mitigators
No.
that he did plead guilty over his lawyer's objection, which I've never seen. And again, I said that's either bravery or stupidity, but he did it. He did it here. I truly do find that the defendant's youth is a mitigating factor in that he's now 19
No,
years
Judge.
old.
No.
And he was 16 at the time that he admittedly committed these offenses. I find as mitigating factor in part, but in part it scares me, the defendant's mental diagnoses. And I will explain that in greater detail without getting into the specifics of the mental health, but it was admitted as part of the evidence. Dr. Yannick wrote the court and indicated that the defendant suffered from oppositional defiant disorder, which is an explanation, but it scares me. And I will explain why that is, because if he had or has oppositional defiant disorder at some time, then maybe he'll have it in the future and he'll oppose and defy. So I don't give that much weight. But as I continue to read, I'm not a psychologist, but to use language that most of us can understand, what has happened is he's grown up in that his diagnosis has changed in this letter. The May 2023 letter that included the word hilarity that Ms. Ryan asked to be admitted was admitted. That letter dated May 2023 from the Porter County Juvenile Detention Center had that word. It was allegedly sent to somebody in England. The defendant was 16 years old at that time. So those are the aggravators and mitigators that I have set forth, and I've said which counts will be concurrent, which counts will be consecutive. So the question then becomes is, should he go to prison? And if so, how long? And if not, what should he do? And for how long? So and why?
So 3 people made it up to this point and left. They're never going to know. Why would you do that? Isn't that crazy?
Everybody that's spoken has tried to say, well, this is what's going to happen. We think this is going to happen. We think that's going to happen. We don't know. We hope, we pray that Ryan Krajewski, now 19 years old, doesn't do this anymore. All of us in this room hope that. Everybody has predictions, but if that's the case, we could all win the lottery.
No,
So the only thing that
I think the cap is 7 years. I think the cap, the most he can get right now is seven years, I think. So if you guys are expecting a 30-year prison sentence, I think you should check the law.
I can base
Maybe I'm wrong.
anything that's happened, is going to happen in the future is what has happened in the past. So you could go back and say, well, he started committing crimes when he was 13. And he was really smart and he knew computers when he was 13. All that is true. I accept that is true. I accept it's true. He writes a letter in May of 2023 from the JDC to England and has the word hilarity in it. Mr. Voga talked about Ryan Krajewski being waived from juvenile court to adult court. It's my memory that at the time that he was waived from juvenile court to adult court, that he was transported to the Porter County Jail from the juvenile detention center. There's a rule that says that people under age 18, I think, are supposed to be at the jail separate from.
He stated.
He stayed at JDC.
Did he ever go to the jail for a couple of hours?
No, they no longer have that distinction separating.
Because he can't be at the jail as a juvenile.
Right.
Right.
Which I was going to say, which we fixed. All right. Because juveniles are not to be with adults in the Porter County Jail, or not to see them or be near them or hear them in the Porter County Jail. So what evidence is there? I mean, they teach people, let's do something called evidence-based decision-making. So the only evidence in reality that I have to go on based on what Ryan Krajewski has done when he's been in the jurisdiction of this adult court, Porter Superior Court 2, is this. I talked at length about Mr. Voga's statement, which I thought was improper, in June of 2023 regarding nobody got hurt. And I said, well, thank God there was no fire. Nobody needed an ambulance. But I first saw Ryan Krajewski on June 21st of 2023. At that time, I set bond for him and then released him to Medina, Ohio, with certain restrictions. Those restrictions dealt with phones, internet, computers, and everything else. There was a notice of violation of pretrial release that was filed on February 7, in which he, and I've used the word toxic, which is what was alleged in his notice of violation of pretrial release between December 4, 2023 and January 6, 2024. We had a hearing and I did not revoke Mr. Krajewski's pretrial release at that point. So evidence-based decision-making says this. So since June 21st of 2024, Mr. Krajewski, when he was 17 or 18, used Discord to use the internet, and also had the Oculus glasses in a closet. So what is the evidence regarding what hasn't, what Mr. Krajewski, now Ryan Krajewski as an adult, what hasn't he done since June 21st of 2023 with police officers from federal agencies, from Medina, Ohio, from Porter County Sheriff's Department, from Portage, from Valparaiso. Everybody's looking at everything that he does, which they should. And what hasn't he done since June 21st of 2023? He hasn't communicated any threat to a school. So the best evidence as to what might happen is the best
Neither have
evidence
I.
that's what's happened in the last 2 years. So, and what happened between January of 2023 and June of 2023 is, I don't know, he got 6 months older. But what happened since the time that I placed him on pretrial release is he's not violated by communicating with any school.
Neither have any of us.
So should he spend the next 7 years in the Indiana Department of Correction? Should he spend 7 years or years or months
Thank you, Kimby.
additionally in
Thank you.
Porter County Jail? So I'll look at the sort of philosophical arguments for incarceration. And as I look out at Mr. DiCarlo, I think, oh my God, I want to keep his kids safe. Well, I want to keep everybody's kids safe. As I said to you, my kids went to these schools. I want kids in Medina, Ohio to be safe. That's what I want first. So there are sort of 4 philosophical reasons for incarceration. And the first one I just said, keeping the kids safe. So one reason for incarceration is you put people in prison or in jail so that prevents them from harming other people while they're in prison or while they're in jail, because they can't, because they're locked up. That is one of the reasons. Another of the reasons is to punish wrongdoers for what they've done. That's called justice. When you violate the law and there's supposed to be justice, you should be punished for what you have done. Another purpose of incarceration is deterrence. Ms. Ryan has stood up and said, well, let's send a message. You can't do this in Porter County. So therefore, we're going to scare the bejesus out of everybody else, and nobody else will ever do it. So the question is incarcerating Ryan Krajewski going to deter anyone else from Ohio or Porter County or anyone else from making a threat to a school in Porter County? And lastly, one of the purposes of incarceration is rehabilitation. So I want to go through those. And then I will explain my sentence eventually. I promise I will. When I said the first purpose is punishment or prevention of harming others, and I looked to Mr. DiCarlo because he talked about the victims that he's seen and having a child himself. And as I've said to you, I have kids that went through school. I'll have grandkids. I mean, I have grandkids, but they will be in schools somewhere. So the people who are parents or grandparents understand what it's like to have a kid that goes to school. And I explained to you, my wife was a teacher, and I didn't want to get a phone call that said your school's on a lockdown. And it was interesting to hear from Officer Howard that his wife was then worried about him as a police officer and whether or not he was going to be hurt. So the question is sending Ryan Krajewski to prison or jail going to prevent future calls to schools? Absolutely it would. He couldn't when he was locked up. So that says that he should go to prison to prevent those future calls. Is this sending him to prison or jail going to deter future acts? I don't think so. I don't think Ryan Krajewski or people like him would have known of what sentences would have been in Porter County, Indiana, being from Medina, Ohio. Is this going to punish him? It certainly would, being in prison. Would this rehabilitate him? I don't think so. So the question is the real question, and Ms. Ryan started this by saying, what do you think he'll do in the future? That's what she said. And that's really the question before this court. As I sit here now, if I think Ryan Krajewski is going to call schools with bomb threats, he'd be locked up in a second. We have people here to lock him up. If I don't think he's going to do this in the future, and as I said, I don't have a crystal ball, then locking him up to prevent these actions would be of no matter because he wouldn't be doing them anyway. So I find because he hasn't communicated with a school specifically in any way, since I told him not to on June 21st of 2023, that he does not need to be incarcerated further to prevent communications with schools. So therefore, I believe his sentences should be served on probation, and I will explain that. But there are significant conditions as to his probationary sentences. So the sentences on counts 3, 4, 5, 6, and 7 are each 2 years in the Indiana Department of Correction. As I've said to you, count 6 and 7 are concurrent with each other and concurrent with count 3. So that is a 6-year sentence in the Indiana Department of Correction. I am suspending all but time served on counts 4, 5, 6, and 7. The 2-year sentence on count 3 will be served as follows. It will all be suspended except for 138 days to be served in the Porter County Jail or the Porter County Juvenile Detention Center with credit for 104 actual days served. The probationary sentences have special conditions of probation. The defendant lives in the state of Ohio. The defendant's probation may be transferred to the state of Ohio upon payment of appropriate transfer fees. The interstate compact on transferring of supervision between felons between states applies. The special conditions of probation that apply to Mr. Krajewski are as follows. He has 90 days house arrest. The house arrest conditions match the restrictions set forth in the ICU monitoring letter that Mr. Vogel filed with the court on July 10th. That is, Mr. Krajewski will be allowed to leave his residence to attend court appearances school, work, church, community service, and medical appointments. He may grocery shop once a month or any other movement for which he must receive court approval. Otherwise, he'll be on house arrest. If he violates house arrest, his bond or his probation will be revoked, and then he'll spend 6 years in the Indiana Department of Correction. Additionally, the defendant is ordered to continue his mental health treatment as set forth again in the letter that was provided from Mr. Boga this past Wednesday. If he fails to continue his mental health treatment, and the court is made aware
Fine.
of that,
Yes.
your probation will be revoked. And you may go to the Indiana Department of Correction, to prison. Do you understand that?
Yes, Your Honor.
You are ordered to complete 250 hours of community service. You may not do that near a school. Do you understand that?
Yes, Your Honor.
We have heard of your ability to use computers, cloaking devices, VPNs, hiding things. Your
Not 100% sure where he lives right now, because remember, he's been in juvie. He's been in juvie for a while. And he committed crimes in Indiana and Ohio, and this is Indiana. So I don't know. I don't know what Ohio's going to do. I mean, there are a few courts that do live stream in Ohio. I don't know where that came from. So I might be able to get it. I don't know.
use of the internet and computers will be restricted as follows. Number one, you are prohibited from communicating in any matter with a school unless you are enrolled as a student in that school. What I heard Mr. Voges say earlier is you've changed jobs, you're working 40 hours a week, and you want to go to college. Paragraph 1 of the Internet Guidelines Agreement says you are prohibited from communicating in any manner with the school unless you are enrolled as a student in that school. That means if you matriculate, if you enroll, I don't know what the word is. If you get into a college, then you may communicate with that college. You can't communicate in any way with the school, high schools, middle schools, grade schools, colleges, unless you are admitted. Do you understand that?
Yes, Your Honor.
You cannot access the internet without prior approval by me or by your probation officer in the state of Ohio. Do you understand that?
Yes, Your Honor.
So what I want you to understand then this, if I see something that says toxic and I find that it came from you, you've already been sentenced to 6 years in the prison. Do you understand that?
Yes, Your Honor.
Ms. Ryan wanted us to know the efforts that you went through to hide who you were. And through the efforts of all the police officers in this room, they were able to figure out who you were. But your third condition of probation is that you are prohibited from deleting, erasing, or tampering with information on your personal computer or device with the intent to conceal activity. But that's kind of a no-brainer because you're not supposed to be using it anyway. But if you get prior approval, you then can't delete that which you've used with prior approval. Do you understand that?
Yes, Your Honor.
Now going back to what we learned about VPNs and hidden messages. If you are allowed to use the internet, you're prohibited from possessing or using any data, encryption technique, I'm throwing this in, such as a VPN or any other program or smart program that you can figure out to conceal your activity. Do you understand that as well?
Yes, sir.
Those are the special conditions of your probation. I thought about this a lot. Anyone who's a parent thinks when they send their kids to school every morning that their kids come home safe. I think, Mr. Krajewski, that you've demonstrated to me since June 21 of 2023 that you're not going to communicate with the school or threaten or terrorize anyone. If I felt that you did, you would be going to prison this afternoon and not getting out for a long time. Do you understand that?
I understand that.
I don't want you to go to prison because prison is a dangerous place. But if you violate these terms, that's where you will go. You are now an adult. Do you understand that?
Yes, sir.
All right. You must report to probation. It left off one other thing. The home detention in Medina, Ohio will be monitored by Medina, Ohio probation. If Medina, Ohio probation wishes to use ICU monitoring from Maryville, Indiana, they can. If Medina County, Ohio, or whatever county Medina is in, wishes to use their own home detention, they may. The transfer of Mr. Krajewski's probation to the state of Ohio will entail these specific conditions of probation, as well as anything that happens in Medina, Ohio.
Judge, I would also ask, because you've ordered him to continue with his counseling and therapy, that he be required to sign a release of information, because I know therapists have with HIPAA law.
Special HIPAA, yeah.
Yeah.
As an additional condition of your probation, you must sign a release which will allow probation either in Porter County, Indiana, or probation in Medina, Ohio, to receive copies of the records from the mental health that I've ordered you to receive. If you fail to do that, your probation will be revoked. You're smart enough to understand all this, that if you screw up, your probation will be revoked and you go to prison. Do you understand that now?
Yes, sir.
All right. Good luck to you, Ryan.
Thank you.
Judge, just as a point of clarification, because I know that I have been engaged in a lot of conversation about this home detention. I know that the Ohio Parole Authority is the one that conducts the Ohio home detention for a period of 90 days.
That is their
You-
cap.
Do you have a preference? In other words, should I reach out to the Ohio Parole Authority with your sentencing order when I get that? Or should I just leave that between Porter County Probation and ICU? But I'm just looking for some direction.
Well, the Porter County probation officers who will handle the interstate compact are present in the room.
Oh, okay. So we can ask, so I can, if they're interested in talking. Okay.
Mr. Krajewski, you may not leave the state of Indiana until you have visited probation and paid the interstate transfer fees, which will allow you to then leave the state of Indiana. But you're to go straight to the state of Ohio. You're not to leave the state of Ohio. It's going to be late Friday night in Ohio when you get to Ohio, so you won't get an ankle monitor tonight. But my guess is you're either going to get one Monday in Ohio or come back to ICU if that's what it takes.
Of course, JJJ gets his own way.
I gestured to her. I just wanted to make sure that, and I think that Rachel's got it covered.
the $230 for probation fees and the transfer fees $125. To be adjusted.
Mr. Krajewski and his parents will pay that before he leaves the state of Indiana, or he'll wait. All right. Anything else we need to address?
Judge, because this. Sorry, because this was an argue sentence. Does he have to be advised of anything?
You know what? That's a good question, because the plea,
Ginny also asked. Two people asked.
paragraph 10 of the plea says, as a further consideration for this plea agreement, I waive my appellate rights for the conviction, any restitution order implying, and the sentence.
Okay.
As long as it's consistent with the plea agreement. The plea agreement said that the sentences could be 3 years on each count. The counts could be served concurrently or consecutively. Therefore, the plea is within, the sentence is within the terms of the plea. Appellate rights are waived under paragraph 10.
Go get him, Tiger.
That will be all.
All rise.
The good news about all of that is if he violates probation, which he has shown that he does, he did it before, he's going to prison. So he's not going to prison right now. He can't get on the computer. He can't do anything right now. If he does, and I think with his aversion to authority disorder, that them telling him he can't get on any computer is just going to make him get on a computer as soon as possible. He's going to try it in a different way. He's going to get an Apple Watch. No, he's going to try a different way. Like the judge said, no VPN. That's really, 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 really hard to enforce. But I see two things happening. I see this little kid thinking he's smarter than the local police station, which he might be. And I see him getting a probation violation. There's ways. There are ways to. So VPNs don't make you invisible. They just make you harder to get. I don't know if I know. I think it's 6 years, 7 years. I don't know. Somebody will say it. Somebody else say it. I was trying to set up my OJ stream and I missed that. I had to get some work done. So I missed the sentence. All I heard was probation and I lost interest. I heard the judge say probation and I'm like, that's it. I'm out of here. What question? Oh, sorry. I'm sorry. You ask a question, I answer it, and you call me an ass. I am an ass. So it's valid. But geez. Virtual private network. Anyway, everybody should be using VPNs. I'm just going to put that out there. Yeah, it makes things a little slower. It makes you working a little slower. But everybody should be using VPNs. I'm a firm believer in that. Even if you don't do anything wrong. But anyway, he does have a job. Oh, God, I know he said it. I can't remember because I didn't care. So what if he has a job? Yeah, well, yeah, most companies do make you log into a VPN before you get into theirs. You should be using your own VPN to log into their VPN. You're down with ODD? Yeah, you know me. Sorry. I am going to do OJ right now because 2 people asked for it. My Lord, you guys are like kindergarteners. So I'm going to do OJ only because I feel so bad about not streaming this morning, but I was not feeling good at all, like at all. So I just laid there. I couldn't even sleep. I just laid there and I was like, ugh. But just laying there is enough for rest. I feel fine now that I just laid there for a while. I watched Born to Kill. I just watched episodes of Born to Kill today. I didn't make any more videos or shorts or streams, which puts me back now more days than I wanted to be. But that's fine. I'll make it up. I'll do OJ now. See you guys in a few minutes. Thank you so much for coming to this special live stream. This was good with the daytime right there and everything. You know what I mean? Yep. Jude, I'll see you. I hope John the Beagle dad knows I'm doing OJ. He's gonna be like Hightower in Police Academy when he missed out on gunfire if he finds out I did OJ without him. Banging his head on the wall. John, don't bang your head on the wall. I'll see you guys soon. Bye, guys. See you tonight in Bill's stream if he streams. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes mirror sky so blue. In her jokes, there's a truth so true. With each string, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle